got questions. We've got answers. We have the man to answer them. Jeffrey Levine from Buckingham Wealth Partners. Jeffrey, welcome back to another episode. That's the hammer.
It is great to be with you as always, Bob.
It's so great to be with you too. I've got a question in my inbox. It goes like this. I just got into a car accident and I think I'm going to be sued. Can I transfer my assets into a trust or somewhere else to avoid them being taken?
It's a really interesting question. And unfortunately, it's a question that's often asked once it's too late, as is the case here. Now, it's important to know that property rights are generally a matter of state law. So the exact rules vary from state to state. However, in all states, or at least all states that I have ever looked at, they have rules for what is called fraudulent conveyance. And effectively, you cannot just shift assets out of your name when you know you're going to be sued in order to say, well, I can't get them anymore. They're in a trust and I gave up my rights. If you know you're going to be sued or you are being sued, then the fraudulent transfer, fraudulent conveyance rules kick in. And while, again, each state is different, in the majority of states, there's about a 4-year look back on that. So it doesn't mean that automatically, if something happens, it would be considered a fraudulent transfer. But in many instances, if the creditor can kind of show that you would have a reasonable expectation of being sued within that time, then certainly there's going to be a challenge there. And obviously, if you've already had that incident and you're like, well, I never thought of transferring my assets until yesterday, and I just happened to get into a car accident the day before. Your argument about I didn't move them just to avoid creditors getting them is kind of difficult argument to make.
Right. So not all assets are treated the same. Would someone's 401k or IRA be protected?
Great question. So the answer could be actually different on both of those. So you're right. There are differences in assets. Effectively, from an asset protection standpoint of view, you could think about it in a couple of levels of different protection, right? So you could have the actual asset itself, the thing you purchase could have certain protections. For instance, many states offer homestead exemptions, right? Where your primary residence is yours and no one can touch it no matter what. Or in extremely limited circumstances. There's also a lot of protection in states on things like annuities or life insurance, et cetera. So the actual investment that you have in some places can offer the protection. If it's not the investment, so like a stock or a bond, et cetera, doesn't necessarily come with its own creditor protection. But if you wrap that investment in an account that offers creditor protection, so that could be an IRA, it could be a 401k, et cetera, you may get that protection. Now, you specifically asked about IRAs and 401ks. In general, not always, but in general, 401ks receive creditor protection under ERISA, which is very, very strong in all 50 states. IRAs, on the other hand, receive creditor protection under state law. And so it's going to depend upon your specific state's rules. Now, some states are very good about that, and others, a handful of states, don't have nearly the same level of creditor protection. And then finally, if the investment itself or the account don't offer the creditor protection, then we can start kind of artificially creating layers. I like to think of it as the onion, right? And as you peel back one layer of the onion, well, you get to the next. Then you get to the next. And how many layers there are can determine how much creditor protection there is. And that could be through the use of elements like a trust, right? An irrevocable trust where you're parting with those assets. In most states, you have to do it for someone else. There's a handful of states that have what are called self-settled trusts, where you can effectively put money into a trust for yourself. The other way you can go about doing this is with some sort of corporate entity. So whether that be with an LLC or a corporation or something like that, you start creating layers, and instead of doing the investment directly, you open up an LLC and do your, investing through there, and that can provide some level of creditor protection as well. Again, every circumstance is different. Rules in each state can kind of vary, but those are some high-level guidelines for folks.
All right. So one last question, not to peel more layers in the onion, but what if
this person has I have a feeling that there's a couple people already crying.
I'm starting to cry. I know. What about joint accounts? They're not the same, obviously, as IRAs and 401ks, but would all of the money in a joint account be subject or at least potentially at risk?
Yeah, so all of it could be at risk. It depends on the situation. In some cases, it might only be a portion of it. It's really going to depend upon the facts and circumstances, and again, as well as state law too. So if you're concerned, a joint account is not your best. It's certainly not the best place to leave it. It also depends upon how that joint account is structured, right? Are you, is it structured truly as joint with rights of survivorship? Is it a tenants in common type of joint structure where you're in it with someone else? Because when you have a tenants in common ownership, you own kind of an undivided portion of that, whereas joint with rights of survivorship as a whole is a slightly different. So again, facts and circumstances really matter here, but at a high level, if something has happened in your life and you're concerned you're going to be sued, it's too late now to ask whether I should be moving assets, or at least in most instances, it is.
You answered that reader's question and then some, and hopefully he'll be driving more carefully in the future, and hopefully he won't get sued, but you nailed it.
Yeah, well, fingers crossed for this individual that everything goes well, and for the other individual who was in the car accident. But if you've got a question for us, we would love to ask you, and we promise not to fraudulently transfer any information to you, or at least give it our best effort. So let us know. Email us at askthehammer@buckinghamgroup.com. Again, that's askthehammer@buckinghamgroup.com. And Bob and I look forward to answering your questions real soon.